Is it a felony or a? I don't have it by page. Before or after Sunny Boy? Okay, Welter, Planton, Hill, Eric Harris, okay.
What's the last name?
Okay, you ready over at the jail? Good morning, can you hear me? I can't hear you.
Is it Eric? It's Eric. Let's see, Eric.
All right, you're here this morning, folks, for your first appearance hearing. There's three purposes for this hearing. The first is to determine if there's probable cause for your arrest, whether or not there were reasonable grounds to believe a crime was committed and that you're the person who committed the crime. If I find there's no probable cause for your arrest, one of two things may happen. I may give the state up to 24 hours to produce additional facts to show probable cause, or I may direct you be released. If you're released for lack of probable cause, it does not mean the case is over. It only means you'll be released from custody. If the state wants to proceed against you on these charges, it has the right to do so. The second purpose is to determine whether you should have a lawyer appointed to represent you. You have a right to counsel. If you have your own lawyer and you want him or her present, let me know that and I'll direct the bailiff to attempt to reach that lawyer. If we can't reach your lawyer, this proceeding will have to be delayed. If you want to have the public defender appointed to represent you, please let us know. I'll appoint a public defender if you qualify for the services. You must fill out completely an application for indigency, which will be provided to you, and the clerk of court will determine if you meet the statutory criteria for having a public defender appointed to represent you. You'll be charged $50 for the processing of the application, which is due 7 days from the date of the application. Please understand that the services of the public defender are not free. If you eventually enter a plea of guilty or no contest, or you're eventually found guilty of the offense with which you've been charged, then a judgment may be entered against you for the reasonable value of the public defender's services. The third purpose is determine what type of pretrial release, if any, should be set in your case. Whether you may be released on your own recognizance, on a monetary bond, or on pretrial release. Each of you has the right to remain silent under our Constitution. You're not required to say or do anything, and anything you do say can be used against you. You also have the right to communicate with counsel, family, or friends, and if necessary, you'll be provided with reasonable means to do so. Okay, we're ready to go, and I understand the jail wants Eric Harris out of order. Please come on up to the podium. I'm not getting any sound from the jail. Okay, Mr. Harris, you're here this morning charged with aggravated battery on an officer or firefighter. I do find probable cause for the charges. Does the state want to be heard as to?
Judge, actually, I would like to be heard in regard to Mr. Harris.
Okay,
And to find his probable cause affidavit. My notes indicate that there's no indication in the course of this probable cause affidavit that the alleged victim in the case is a law enforcement officer.
right, that is correct. I find probable cause for the aggravated battery, but not that it's an officer or a firefighter. It appears to be another patient a patient.
Thank you, Judge.
Your Honor, based on the level of violence, the alleged threat to kill, Your Honor, and his criminal history includes, at a Broward 2016, 2015 theft, 09 delivery of cocaine with a violation of probation, 07 possession of cocaine, 04 loitering and prowling. I see out of the state of Georgia in 2000, he had a stalking, Your Honor. And, a moment,
What's the state asking for a bond?
I'm sorry, $10,000, no victim contact.
Okay, and did the public defender want to be heard on the bond? I can't hear you. There we go.
Hello?
There we go.
Oh, okay. You can hear me now?
Yes, I can.
Okay, first thing, I basically can hardly hear you all, but besides that, Judge, and speaking with Mr. Harris, he's been residing, well, he's 51 years old. At this time, he is working. He works for a company called GLU in customer service. He's been working there for approximately over 2 years. He's making it fluctuates, it's by commission. So last week, he said he made about $100. Unfortunately, he lives in a homeless shelter in Pompano. Judge, I believe what the state was asking for was a $10,000 bond. Mr. Harris financially cannot come anywhere close to that bond. We'd ask you to set a more appropriate bond, and also ask you to sign an order allowing us to photograph Mr. Harris's injuries.
Okay, certainly the order to photograph the motion to photograph the injuries, that's granted. I'll sign that order. I'm going to set bond in the amount of $7,500. In the event that Mr. Harris posts bond, I'm going to order him to have absolutely no contact with the alleged victim who was the patient, but my paperwork, I don't think, has the patient's name.
It does, it should be, if you look right above, right above the offenses charged, where it says name of victim, on the first page of the PC. No, I'm sorry. Okay. What I know of the witness, did anyone in the house see them?
Yeah, Rodolfo, okay, absolutely no contact with Rodolfo Avila. Good luck to you, sir.
Yes, Judge.
All right, let's take the Perfection Tammy Lee parent. A false identity to a law enforcement officer and driving while license suspended. The state has anything to add?
No, Your Honor.
No? Okay. Ms. Parent will be ROR'd then. Okay. Whitney Morell.
Paul Ryan, I believe, Judge.
All right, facility, Your Honor.
Yes, good morning. Okay, Ms. Morell, you're here on some added charges, grand theft, bond is set in the amount of $100, petty theft, felony petty theft, 2 counts, $750 each, uttering of forged or false instrument, bond is set at $1,000, obtaining property by fraud, bond is set at $5,000, and dealing in stolen property, bond is set in the amount of $7,500.
100,000.
On the grand theft, did I say 100? If I misspoke, I apologize. On the fraud or the grand, well, it's 1,000 on either one, so, okay. All right, I do find probable cause for the charges, ma'am. Good luck to you. La Drenisa Denise Nolshan.
Ms. Nolson is here, present, Judge, at Maine.
Okay.
All right, thank you.
Okay, ma'am, you're here this morning charged with grand theft auto and 2 violations of felony probation. As to those, no bond is available. I do find probable cause for all the charges. As to the grand theft, bond is set in the amount of $1,000. Good luck to you, ma'am. You're going to have a hearing on your violation of probation on August the 15th.
Good luck, ma'am.
Ernestine Bryant.
Yes, ma'am. No prior, Your Honor. Yes.
Good morning, Miss Bryant. You're here this morning on a violation of felony probation. No bond is available. I do find probable cause. You're going to have a hearing on that violation on August the
You call
16th.
me back if you need to.
Good luck to you, ma'am.
Thank you.
Shunte McGee.
No prior, Your Honor.
Good morning, Miss McGee. You're here this morning charged with grand theft. I do find probable cause. Your bond is set in the amount of $1,000. Good luck to you, ma'am.
Okay, thanks.
Stephanie Sanders.
That's what's present, Your Honor.
Okay. Good morning, Miss Sanders. You're here this morning on a misdemeanor capias, as to which bond was set in the amount of $500. There's also, that was on a possession of paraphernalia, no show at calendar call. And there's also 2 warrants for violation of pretrial and violation and a felony capias. No bond is available as to either of those. I do find probable cause. You're going to have a hearing on August the 17th, I think it looks like. Good luck to you, ma'am. Okay, Milton Fernandez.
He's in Conte, Judge.
Conti?
I'd like to resolve this if possible.
Yeah, sure, let's see.
Good morning, ma'am.
Good morning, sir. Okay, you're here on a capias charging you with driving while your license is suspended with knowledge. Let's take a look. You've got some suspensions for failure to pay.
Judge?
Yeah,
Oh, wait, no. Just so the court's aware, he's being held, he resolved a felony VOP. He's county sentenced with a release date of October 23rd, 2017. So I don't know if maybe, if the court's inclined, maybe just Brian wants to go to his division, have a chance to talk to him.
well, interestingly enough, he's got 2 prior DWLSs, but they were disposed of on November 14th, 2012. So I'm inclined to release him on his own recognizance on this and let it get set in the division.
Well, Your Honor, I would ask you not, because frankly, and I would imagine the defense.
No, we don't want him ROR'd. He won't get time served on the charge. Mr.
Okay.
Fernandez and I discussed this, and he indicated to me that he would like to resolve the case today and get it over with. Is that right, Mr. Fernandez? Is that what you want to do?
Mr. Fernandez, I want to make sure you understand that if you resolve the case today to get it over with, it's going to cause your driver's license to be revoked for a period of 5 years. You understand that?
Yes, ma'am.
Okay, all right. And even knowing that, you don't want to see if you can't get it reinstated?
No, ma'am.
Okay, all right, so you want to enter a plea of no contest to the charge of driving while your license is suspended with knowledge?
Yes, ma'am.
Okay, I'm going to adjudicate you guilty, sentence you to time served. There's court costs, and you'll have 180 days from your release from jail to get those court costs paid. Good luck to you, sir.
Good luck, man.
All right.
I'm sending you your driving record, too, so you'll know what's open. Paul Thomas.
North Broward.
North Broward, Your Honor.
Mr. Thomas indicated to me that he would like to resolve this matter as well.
Okay, Mr. Thomas, you're here this morning on a misdemeanor capias for trespass. You want to resolve this case this morning with a plea of no contest?
Yes, ma'am.
Okay, and have you got someplace to go? Where are you gonna go?
I'm pretty homeless, but I got some places where I could go.
Okay, you want to stay for another day and have something good to eat?
No, man, I just want to go home.
Okay,
To
all
my
right.
mother.
Okay,
I just want to go home because they never gave me a court case, and that's why I got a warrant.
All right,
Okay,
Mr. Thomas.
right.
You're getting out.
okay, I'm going to
you.
accept your plea of no contest. I'm going to adjudicate you guilty, sentence you to time served.
Thank you.
There are court costs. You're gonna have 180 days to either pay him or do community service at $10 an hour for those court costs. Good luck to you, sir.
Our Spanish interpreter is here, Judge.
Oh, good, thank you. Jeffrey Hutchinson?
Kirsten on Judge, we have Hugo Sanchez Gomez. I don't know what page. I wasn't advised. I'm gonna try and figure it out right now.
Okay, is that who you have standing next to you?
That is correct, Judge.
Is he the only one that needs the Spanish interpreter?
Español, otra persona necesita español. He's the only gentleman, Judge, that raised his hand.
There's Mr. Garcia in the North Broward Detention Center, also requires a Spanish interpreter.
Okay.
He's on page 10, like halfway through.
Who's the gentleman that you have at the,
I just found him. He's Hugo Sanchez Gomez. He's on page 17, so he's going to be towards the back of your stack of PC affidavits, Judge.
yeah, well, I'm getting there anyway, so. Okay, I have Mr. Hugo Sanchez Gomez, and the other gentleman who needs the interpreter, Garcia, is he before Sanchez
Garcia
Gomez?
Zalunga. He's on page 10, about halfway through the docket.
What's the last name again?
Garcia Zalunga. Ivan Garcia Zalunga.
In the meantime, would our interpreter raise your right hand? Do you swear that you will accurately and completely translate everything I say to the Spanish-speaking defendants and everything they say to me?
I do, Esteban Rojas.
Okay, well, let's do Mr. Sanchez Gomez first, because I'm having trouble finding the paperwork on the other guy. I'll look for him in a moment. Okay, and Mr. Sanchez Gomez, you're here this morning charged with grand theft.
Señor Sánchez Gómez, usted está acá hoy, esta
Judge, you can hardly hear the
mañana.
interpreter.
Señor Sánchez Gómez, usted está acá esta mañana acusado de hurto mayor.
I do find probable cause for the charges.
Considero que existen indicios probables de delito.
Your bond is set in the amount of $1,000.
Su fianza queda fijada en el monto de $1,000.
Good luck to you, sir.
Buena suerte, señor.
Thank you, Judge.
Okay. Okay, I have found Mr. Garcia Zulaga. Ivan Garcia Zulaga.
Those prior, Your Honor.
Good morning, sir.
Buenos días, señor.
You're here charged with burglary of an occupied dwelling.
Usted está acusado de hurto en una morada.
I do find probable cause for the charges.
Considero que existen indicios probables de delito.
Did the state and public defender wish to be heard as to bond?
Quería decir algo el defensor público y el fiscal con respecto a la fianza, sí.
Your Honor, based on the allegations in this case,
Su señoría, dadas las acusaciones en este caso,
I'm very concerned for the safety of the alleged victims
me preocupa mucho la seguridad de las supuestas víctimas.
and the community.
Could you repeat that last
And the
part?
community.
Y la comunidad también.
State is requesting a $50,000 bond.
La fiscalía solicita una fianza de $50,000
No victim contact.
y que se le prohíba tener contacto con las víctimas.
And should Mr. Garcia Zulaga post bond, pretrial release with a GPS monitor.
Y si el señor García Zulaga pudiera pagar la fianza, entonces solicitaríamos que una vez que sea puesto en libertad, que deba someterse a condiciones preliminares con un monitor GPS nivel 2.
Your Honor, due to the language barrier, I was not able to speak with this gentleman.
Su señoría, dada la barrera del idioma, yo no
If you
pude
want to
hablar
ask
con
him
este
some
caballero.
questions now through the interpreter, you certainly can.
Si quiere
Thank you,
hacerle
Judge.
preguntas mediante el intérprete, puede hacerlo. Gracias, señora juez.
Sir, how long have you lived here in South Florida?
Señor, ¿cuánto tiempo ha vivido usted acá en el sur de Florida?
4 años y 9 meses aproximadamente, desde octubre.
Four-
En octubre cumpliría 5 años.
4 years and 9 months approximately. In October, it would be 5 years.
Who do you live with?
¿Con quién vive usted?
Con mi esposa y mis 2 hijas.
My wife and my 2 daughters.
How old are your daughters?
¿Qué edad tienen sus hijas?
9 y 11 años.
9 and 11.
Are you working right now?
¿Tiene empleo en este momento?
Sí, soy músico.
What
Yes,
type of work
I'm
do
a
you
musician.
do? I'm sorry?
I'm a musician.
And who do you work for?
¿Y para quién trabaja?
Bueno, realmente es un trabajo independiente.
I'm a freelancer.
Pero pues hay varios sitios donde realizo mi trabajo.
But there are a number of locations where I do my work.
Do you have any money in the bank?
¿Tiene dinero en el banco?
No creo que tenga lo suficiente.
I don't think I have enough.
Is there anyone in the community who could bond you out, friends or family?
¿Hay algún miembro de la comunidad que pudiera pagar su fianza, sea parientes o amigos?
Espero que sí.
I hope so.
Who would that be?
¿Y quién sería esa persona?
Probablemente mi tío.
Probably my uncle.
Do you have your uncle's phone number?
¿Tiene el número de teléfono de su tío?
No, desafortunadamente de memoria solo me sé el número de mi esposa, pero es un celular y no he podido hablar con ella desde que sucedió este incidente.
No, unfortunately, the only number that I have committed to memory is my wife's number, but it's a cell phone and I haven't been able to speak to her since this incident occurred.
Have you tried calling her or have you not been able to call
¿Ha
her?
intentado llamarla o no ha podido llamarla?
No he podido llamarla porque es un número de teléfono celular y
Ay.
tengo entendido que desde acá no se puede llamar.
I haven't been able to call her because it's a cell phone number, and my understanding is that here that is not allowed.
Judge, I'm going to ask for him to give me his wife's phone number so I
Right.
can call her.
Su
That's fine.
señoría, voy a solicitarle a su señoría solicitarle a él que me dé el número de teléfono de su esposa para que yo la pueda llamar.
561
561
301
301
0280.
0280.
What is her first name?
¿Cuál es el primer nombre de ella?
Natalie.
Natalie.
Are you getting the proper medical attention while you're in the jail?
¿Está recibiendo la atención médica que necesita estando en la cárcel?
Sí, señor.
Yes, sir.
How much money do you think your family might be able to come up with to bond you out?
¿Cuánto dinero cree usted que pueda reunir su familia para poder pagarle la fianza?
Realmente no puedo aventurarme a decir algo. Probablemente con lo que los conozco harán lo posible, pero no creo que vayan a tener más de $15,000. Realmente no sabría decirle. Y pues como usted entenderá, a mí nunca en mi vida me ha pasado una situación de estas.
I wouldn't want to venture a guess. Based on what I know about them, I know that they will try, and they might be able to get together, say, some $15,000 at the most. But nothing like this has ever happened to me, so it's a very difficult situation.
Okay.
Well then, Judge, if they can come up with that, I think maybe a 15, what were you asking for, State?
50.
50? That sounds like that might be beyond their range, Judge. I'd ask the court to consider like a 25.
Okay.
Señora juez, suena como que una fianza de $50,000 está fuera del alcance de esta familia. Yo solicitaría que su señoría impusiera algo como por ahí de $25,000.
Okay, and sir, as I say, I found probable cause. I'm going to set your bond in the amount of $25,000 in the event that you post bond you to have absolutely no contact with the alleged victims, Carol Williams or Sharon Wong.
Bien,
Good
señor.
luck to you, sir.
Your Honor, I'm sorry, go ahead.
Considero que existen indicios probables de delito. Voy a fijar su fianza en el monto de $25,000 y si fuera liberado bajo fianza, se le prohíbe absolutamente tener contacto alguno con las víctimas. Your Honor, could you say the names of the victims again?
Yep. Carol Williams.
Carol Williams
Sharon Wong.
y Sharon Wong. Con esas
Two
dos
other-
personas se le prohíbe
I
tener
beg your
contacto.
pardon?
There's two other listed victims on the second page.
Su señoría,
The-
aparecen enumeradas dos víctimas adicionales.
So Jada.
Jada Williams also
Jada Williams también
and Trinity Allen.
y Trinity Allen.
And Your Honor, the state also requested a pretrial release with a GPS monitor.
Y la fiscalía también solicita que se someta a condiciones preliminares con un monitor GPS.
Okay, yeah.
Bien,
The
sí.
GPS monitors.
Sí, se le ordena, si fuera liberado, se le ordena portar
Okay.
un monitor GPS.
Good luck to you, sir.
Judge,
Buena
I'm going to ask
suerte,
you to,
señor.
I'm going to ask you to sign a photo order on this gentleman.
Yeah.
Voy a
Thank you, Judge.
solicitar que su señoría firme una orden permitiendo que fotografiemos a este caballero.
That's granted.
Bien, se otorga. Gracias.
Okay. All right. And I don't think we had any other takers in any location for the interpreter, isn't that correct?
We're set.
I think so.
Okay.
Thank you. Jeffrey Hutchinson.
Mr. Hutchinson's here, President Judge of Maine.
Okay, good morning, sir. You're here on a misdemeanor capias for a failing to appear in court on a DUI charge. Has no bond of VOP, no bond available. And you will, I do find probable cause, and there'll be a hearing on August the 17th for you. Good luck to you, sir.
Judge, and speaking of Mr. Hutchinson, normally I don't make this request, but this is a 2010 capias. My understanding is, I hope the court has his driving record in front of you. My understanding in speaking with Mr. Hutchinson, he does have a valid driver's license. He lives in Wellington. He was transported down here. He sat in Palm Beach for about 8 days. He advised me he hasn't had any contact with the criminal justice system. He's a registered voter. He thought this was taken care of when he mailed out all this paperwork. And I know sometimes for a person who's new to the criminal justice system, it's easy to believe when, when he sends in all his documents and paperwork, he may have believed that he satisfied all the conditions and the case was over with. Judge, what I'm asking you to do, I understand this is a DUI case. I'm not asking you to resolve it. I'm asking you to keep his court date August 17th at 11 a.m., but I'm asking you at this time to set a monetary bond on Mr. Hutchinson's behalf, considering it's a 2010 capias.
Okay, it's a 2010 capias, and his driver's license is valid now. Does the state have any objection?
Yes, I do, Your Honor. This is Judge Diaz's probation. We don't know what the basis was for the violation of probation. Then he didn't even show up to the VOP hearing, Your Honor.
Okay.
Judge, we can't hear the state at all.
Okay. I'm declining to set a bond. I don't have any information on what the source of the violation was, and that he also failed to appear at the VOP hearing. So, good luck to you, sir.
I don't think this is a violation of probation. It's a capias.
It's a capias that says violation of probation hearing. That's what it said on it.
Oh, it's a violation of probation?
It was a no-show at the VOP hearing.
Mr. Lunder, can you verify
It's
that?
a no-show at a VOP hearing.
Mr. Lunder, he's on probation right now?
I don't see that anywhere.
He didn't show up to a VOP hearing. I'm looking at it in Odyssey right now.
Okay.
And the capias, and
You're
even
gonna
though
have
it's a
to go in.
2010 case,
Their records
the
indicate
capias was
17th
issued
is the
February
VOP. You're gonna have
2016.
to address it with
Okay,
the judge.
okay. The capias was issued February 2016. It's a 2010 case, but the capias was just issued a year ago when he failed to appear at a hearing on his violation of probation. So this way we'll be sure he'll get to the next hearing, okay? Good luck to you, sir.
Yes, Judge.
Devontae Ford.
Mr. Ford, come on up, please.
Good morning, Your Honor.
Good morning. Okay, Mr. Ford is here on a misdemeanor and a municipal ordinance capias.
Correct.
Bond is set in the amount of $250 as to each of them. Okay, did you want to,
Yes, Judge, I'm asking the court to inquire as to his financial status to see if he qualifies for Ms. McLawrence's law office.
okay. Mr. Ford, are you working?
No, ma'am.
Okay, do you have any assets? Do you own a car, a home, anything like that?
No, ma'am.
Okay, I'm gonna find that he does qualify for counsel on the municipal ordinance.
Thank you, Your Honor. Second, Judge, if I may ask him one key question before I proceed. Mr. Ford, my name is George Odom. I'm standing in on behalf of Mr. McLawrence. Do you still have an interest on attending drug court?
No, sir.
Okay. With that being said, Your Honor, I'm going to ask if the court, at least on the municipal ordinance case, being that he does not have any monies, and I understand it's a capious, would the court be willing to arm on the MO municipal ordinance and then just allow him to get the money up for the state charge?
And on the state charge, on that misdemeanor, are there other prior drug?
Well, I'll have to look, but I'm showing it looks, that count one's out of drug court. And it looks like Judge Zeller ordered, Judge Zeller only to, I guess, to have it
Okay.
Respectfully speaking, Mr. Ford, he wishes to ask the court if you would consider resolving his case today. We'd be asking you to consider time served or take judicial notice of the times he already served.
Well, he was in the drug court program. You don't want to go back to the drug court and finish that program?
Do that.
In fairness, I mean, just looking at the language that's on the capious, it looks like Judge Zeller either posting a $250 bond or being brought before. Either way, it looks like she wants to see him.
Yeah.
Well, Judge, if I can briefly interject, if drug court is voluntary by a circuit order, so if he's stating.
Well, that's right. He doesn't have to stay, but he's going to have to tell Judge Zeller why. She specifically said that she should be the only one to handle it. So I'm not in a position to do anything about that case. So the bond on the drug court case on the is $250, and on your municipal
Your Honor,
ordinance,
I'm sorry, and actually, I just realized, it looks like he's already in drug court on count 2, and Judge Zeller put the same language on
Yeah,
that one.
he's in drug court for both. He
Okay.
got a fade to appear. on both.
Okay, all right, then he'll see Judge Zeller, and she'll straighten it out on August the 22nd. Good luck to you, sir.
Thank you, Judge.
Okay. Roland Allen,
He's approaching, Judge. He's here, me.
okay. And
He
Mr.,
declined the services of public defender.
he declined, okay. Mr. Allen, you're here this morning on a violation of your misdemeanor probation, as to which Judge Pohl has set no bond, made no bond available. You'll have a hearing on this VOP on August the 15th. Good luck to you, sir. I do find probable cause.
Good luck, sir.
Jamal Rutledge,
Mr. Rutledge is approaching, Judge.
good morning, Mr. Rutledge. You're here this morning charged with driving without a valid Florida driver's license. Bond is set in the amount of $25. You have a license from someplace else, I guess? You live and work here now?
I know what it says on the booking. I don't think that was the officer's intent looking at the arrest form. He just charged him with operating without.
Yeah, operating
with
without
the
a valid
out-of-state,
driver's
yeah.
license. Right, right. Okay. And I'm showing that he's got no license, but he's also got no priors. Did you want to resolve this morning, sir?
Let the judge know.
You want to resolve it, sir?
Yes, ma'am.
Okay, you understand you're giving up your right to have a trial?
Yes, ma'am.
Okay, on the operating without a valid driver's license, I'm showing no priors. I'm going to withhold adjudication. There's court costs and costs of prosecution. It's going to total about $293. You're going to have 90 days from your release from jail to get that paid. The infraction is dismissed. Good luck to you, sir.
Yes, ma'am.
Darnell Wilcox.
Mr. Wilcox, come on up, please. Mr. Wilcox, your present, Judge of Maine.
Yeah, good morning, sir. You're here this morning charged with DUI. Bond is set at $1,000. DUI with a person under the age of 18 in the vehicle. In addition, there's some infractions that don't require any bond.
I think that count actually, Judge, is based on, not on an underage person, but
Oh,
on
on the
the
on
breath,
the-
results of the breath test.
On the breath test. Yeah. This is, yeah, there was a guy who was, yeah, the high breath, yeah,
Your Honor,
yes.
state is going to be requesting a bond increase. On January 24th of this year, Mr. Wilcox was convicted of DUI and placed on 6 months probation, so it would appear that he just got off probation last month. And also considering how high his breath readings were in this case, state will be requesting bonds in the amount of $2,500 per count on 1 and 2, with an additional release condition, no alcohol or intoxicants.
All right,
Judge,
Yes.
if I can inquire as far, his prior history, besides that DUI that Mr. Lunder stated?
oh, yeah, sure, I'm looking at his driving record. In February of 2016, he was convicted of and suspended for refusing a breath test. In January of 2017, he was convicted of DUI and revoked for 180 days. In addition, there was older charges of open container and I think that's the same DUI from February of 2016.
Judge, the only thing I'd like to bring to the court's attention, Mr. Wilcox is 73 years old. His only source of income is he's on disability. He lives in Miramar. His portion of the rent is approximately $300 per month. Financially, he's not in a big position to post any sort of increase in the monetary bond. I'd ask you to leave the standard bond in place, Judge.
Okay, on count one, I'm gonna leave the standard bond of $1,000. On the high blood alcohol level, I'm gonna increase the bond to $2,500. In the event that you post bonds, sir, you're to have no alcohol or intoxicants. All right, good luck to you, sir. Kirby Smith.
Mr. Smith, come on up, please.
Now the vote.
Okay, Mr. Smith, you're here this morning charged with attaching a tag not assigned to your vehicle, driving while your license is suspended, bond is set at $100, no proof of insurance and careless driving, infractions that don't require any bond, and there is also a misdemeanor capias, as to which bond was set in the amount of $500 for failing to appear at arraignment on a driving while license suspended charge. Okay, I do find probable cause for the charges. I'm showing that you are revoked, but you might want to, based on your driving record, you might want to post bond and get your driver's license reinstated before you go back to court. That'll work out better for you, and the state will likely null pros the charges at that point. Okay, good luck to you, sir. Seth Nunez. Has he got any drug priors?
1 moment.
Oh, yeah, he does. Okay, Mr. Nunez, you're here this morning charged with possession of cannabis. Bond was set in the amount of $100. There's also a driving while license suspended charge that requires no additional bond. I do find probable cause for the charges. Did you?
Judge, considering this is a cannabis charge, I asked Mr. Nunez, he wishes to have his day in court. Would Your Honor, this is a nonviolent offense, would you consider an ROR on Mr. Nunez's behalf?
Well, you know, he was just adjudicated guilty of a controlled substance just a few months ago. So I'm going to leave that bond in place, okay? Good luck to you, sir. Bobby Stanfill.
Good morning again, Your Honor.
Yes.
Mr. Stanfield is approaching.
Yeah, Mr. Stanfill, you're charged with a municipal ordinance. Sir, are you working?
No,
Have any assets?
no,
Okay, then I'm going to appoint counsel for the municipal ordinance.
Your Honor, would the court get involved in this matter for resolution?
You want to resolve this matter this morning, sir?
I don't think I'm guilty, so I'd rather go to a trial.
Okay, that's fine. Your bond is set in the amount of $25. I do find probable cause for the obstructing the right of way, so you can post your bond and have a trial. Good luck to you, sir.
Thank you, Judge. Mr. Stanfield, Mr. McLawrence will be out to see you soon.
Okay, what now?
Mr. McLawrence will be out to see you soon.
Your counsel, okay. Lucas Almeida,
Judge, I've been advised he bonded.
okay. Oops, sorry. Ernest Tynes.
North Broward, Your Honor.
Good morning, Mr. Tynes. You're here this morning on some added charges to two felony capiases. Bond is set in the amount of, okay. Bond is set in the amount of $1,000 as to one of the charges, and the second charge on the capias is an attempted burglary. These are add charges. Did the state want to be heard as to, there's obviously other things holding him?
Yes, Your Honor, I'm just checking to see to get an idea what his bonds are in his other cases. Yes, Your Honor, he's being held on, from what I can see, 1, 2, 3, 4, 6 other burglary conveyances, based on $5,000 bonds on those. Considering this is an attempt, I'd ask for a $2,500 bond.
All right, as to the first charge in the capias, the grand theft firearm, the bond set at $1,000. As to the second, I'm gonna set the bond at $1,500. Good luck to you, sir. I do find probable cause. Bert Byram,
North Broward, Your Honor.
yes.
Going to the
Okay, Mr. Byram, you're here this morning on an added charge, a felony capias, as to which bond is set in the amount of $5,000. I do find probable cause. You're gonna have a hearing on this on August the 15th. Good luck to you, sir. Sheldon Gray.
Mr. Frank's here present, Judge, I mean.
Okay. All right, Mr. Gray, you're here on an added charge of a violation of felony probation, as to which no bond is available. I do find probable cause. You're gonna have a hearing on that VOP on August the 15th. Good luck to you, sir.
Okay, well, I don't understand. What's the added? I don't get that.
Hold on one second, Judge. Thank you, Judge.
Okay. Christopher Frank.
Mr. Frank is here present, Judge, I mean.
Okay. All right, Mr. Frank, you're here this morning on an arrest warrant charging you with burglary, armed burglary, burglary with assault or battery, aggravated battery on a person 65 years or older, aggravated battery, and tampering in felony proceedings. On counts 1 and 2, there is no bond available.
Your Honor,
Oh, yeah.
on counts 1 and 2, they are punishable by life offenses. Your Honor, the state is going to be seeking a no bond hold, arguing for first appearance purposes only, for finding a proof evident or presumption grade based on the affidavit that was given to Judge Usan when he signed the warrant.
Okay,
Which I'm reviewing right now, Judge, if I could have just a moment.
sure. Okay, I'll go back to those two while counsel's reading the affidavit on the aggravated battery on a person 65 or older. Bond is set in the amount of $25,000. On the aggravated battery, bond is set in the amount of $25,000. Tampering, bond is set in the amount of $5,000. I do find probable cause for all the charges.
And Your Honor, we're also going to be asking for no victim contact. I know.
Absolutely.
And I know the courts advised the other defendants, like, if you should be released, no contact. We're asking no contact from this moment. The reason being, it's noted in the affidavit that apparently calls were made from, and I checked the area code Georgia, and obviously calls could be made from the jail, possibly, so.
Okay. Okay, anything from the public defender?
Just one moment, Judge. I'm
sorry.
just finished reading the warrant on both Christopher and Sonny Boy Frank. Judge, we would object to the court setting or finding a holding of no bond on Christopher Frank. Proof, evident, presumption great is the highest burden of proof under our criminal justice system, higher even than proof beyond a reasonable doubt. To support their allegation that the court should impose the most severe pretrial detention sanction, the state has only provided an affidavit. They've called no witnesses, produced no physical evidence, not produced any testimony of any kind, and is asking this court to hold Mr. Frank without bond based on a warrant, which is insufficient. And we would ask the court at this time to set bond for Mr. Christopher Frank.
Okay, based on Isaza, I'm going to find that there's proof evident and the presumption is great. I'm going to hold the no bond on counts 1 and 2. And Mr. Frank, you're to have absolutely no contact with any of the alleged victims, including John Nicholas, Polly Nicholas, and Steve Nicholas. Okay, good luck to you, sir. Okay, Sonny Boy Frank?
Mr. Frank is here, present, Judge Jermaine.
Okay, good morning, sir. You're here this morning also charged with armed burglary, burglary with assault or battery, aggravated battery on a person 65 or older, aggravated battery, and tampering. I am finding as to counts 1 and 2 that the proof is evident, presumption great, and I'm holding those as no bond. On count 3, the bond is set in the amount of $25,000. Count 4, $25,000. Count 5, $5,000. And you're to have absolutely no contact with the alleged victims. The Nicholases, it's Polly and John and and the third alleged victim's first name is Steve. Okay, good luck to you, sir.
I would incorporate the same arguments
Yes.
for Sonny Boy Frank that I previously made on Christopher Frank.
Yes, that record is complete there. Kareem Muwakil. Good morning, sir. You're here this morning charged with a violation of your felony probation. No bond is available. I do find probable cause. You're going to have a violation of probation hearing on August the 15th. Good luck to you, sir. Jeff Delva. Somebody have Jeff Delva?
Judge, he's here at Maine, he's gonna require Creole interpreter.
Oh, okay. We'll see if we can get one. Thank you. I'll recall him.
Mr. Desir as well,
Okay.
the next gentleman,
And Mr. Estenfil?
correct?
And Mr.
Correct.
Geffrard? All 4?
Correct.
Yeah, okay. All right. We'll recall all 4 when we have a Creole interpreter. Thank you. Michael Green?
North Broward.
North Broward, Your Honor.
Yes. Good morning, Mr. Green. You're here charged with unarmed burglary of an unoccupied dwelling and criminal mischief. I do find probable cause. Did the state want to be heard as to bond? What does the state want?
Yes, Your Honor. Just to advise the court of Mr. Green's criminal history. Battery last year, grand theft 2008. He was sentenced to 28 months state prison as a habitual offender. 2007, accessory after the fact, dealing in stolen property and grand theft with a violation of probation. 28 months state prison as a habitual offender. 01, dealing in stolen property and grand theft, 5 years state prison as a habitual offender. Your Honor, the state would be asking for a $15,000 bond and no victim contact.
Okay. Anything from the public defender?
Judge, I know that there's probable cause here for this charge, but it looks like a place that he used to live. So I don't know if that's a mitigating circumstance or not. There might be some other issues involved here as well. I'd ask the court for a $2,500 bond.
Your Honor, I would just note, I used to rent an apartment. I can't go back there now. Let myself in.
Right.
Well, you
Okay.
could, if you're not politely on the
But I
door,
was
they
spending
would
the
let
night
you
in
in.
jail.
All right. Okay, Mr. Green, I'm setting your bond in the amount of $15,000. There's no bond necessary on the criminal mischief and you're to have absolutely no contact with Pauline Black. Good luck to you, sir.
Yes, ma'am.
Ramsey Hassoun.
Mr. Hassan is here, present judge at Maine. He's declined to serve as a public defender.
Okay, Mr. Hassan, you're here this morning charged with robbery. I do find probable cause for the charges. Did the state want to be heard as to bond?
Your Honor, to advise the court, Mr. Assam has a theft 2013, grand theft 2013, dealing in stolen property, false ownership info on a pawn item 2013, and burglary of a conveyance with a VOP 07. Based on the allegations, Your Honor, the state would be asking for a $7,500 bond and no victim contact.
Okay. Mr. Hassoun, I'm going to set your bond in the amount of $7,500, and I'm going to order you to have no contact with Timothy Moreland.
Is there anything I can say, Your Honor?
What do you want me to know?
Well,
Don't talk about the facts of the case.
No, I'm definitely not doing that. I'm staying at a halfway house right now. Unfortunately, I just started a job. I don't really have any friends or family that can help me. If there's any way we can reduce the bond so I can get in contact with whoever I can to see if they can help me, because it's really no family or friends. I'm just going to reach out to as many people as I can, please.
Okay, well, good luck to that. Good luck reaching out to family or friends. And of course, at this point, I'm going to leave it at $7,500. You can always make an application to the division judge to reduce it should you find people willing to postpone for you, okay? Good luck to you, sir. Sure. Todd Youngins?
Mr. Yuggins is here, present judge at Maine.
All right, good morning, sir. You're here this morning on a felony capias and on 2 violations of felony probation. No bond is available on any of the charges. I do find probable cause. You're going to have a violation of probation hearing on August the 16th. Good luck to you, sir.
Good luck, sir.
Jacob Smiley.
Mr. Smiley? He's here, present judge.
Okay, Mr. Smiley, you're here charged with a violation of your felony probation. No bond is available. I do find probable cause. You're going to have a hearing on that violation on August the 15th. Good luck to you, sir. Tracy Gallagher.
Mr. Gallagher?
Good morning, sir. You're here this morning on a violation of your felony probation. No bond is available. I do find probable cause. You're going to have a hearing on that VOP on August the 15th. Good luck to you.
Good luck, thank you.
Clayton Strickland.
Mr. Strickland, come on up, please. Afterwards, see her.
Okay. Mr. Strickland, you're here on a, KP is charging you with, attempted robbery and, attempted robbery with no weapon. Okay, I do find probable cause for the charge. State, did you want to be heard as to bond?
Your Honor, considering it's an attempt, I can advise the state would be requesting a $3,500 bond, no return to the Home Depot mentioned in this particular incident.
Okay, all right. Anything from the public defender?
Defense has no objection to $3,500 bond.
Okay, then I'll set the bond at $3,500 and no return to the Home Depot. It's Home Depot, isn't it?
Yes, it is, Judge.
Yeah, okay,
It's
no,
on Copens and Pompano.
yeah, okay, no return to the Home Depot on Copens Road in Pompano. Good luck to you, sir. Me either. Devin Hicks. Okay. Good morning, Mr. Hicks. You're here this morning charged with possession of cocaine, also possession of cannabis and resisting an officer without violence. On the possession of cocaine, I do find probable cause. The bond on the possession of cocaine is set at $1,000. Good luck to you, sir.
Mr. Webley?
Jason Webley. Mr. Webley, you're charged with grand theft. Bond is set in the amount of $7,500. Fraudulent use of another's identity without consent. Bond is set at $7,500. Filing false documents against real property in this case. Bond is set at $1,000. Fraudulent impersonation or use of another's ID without consent, bond is set at $7,500, and filing another charge of filing false documents against real property. In this case, bond is set at $1,000.
Your Honor?
Yes.
And actually, the state was going to be requesting a bond increase based on the allegations in this case. Essentially, Mr. Webley, according to the allegations, stole someone's home.
Right.
And then stole essentially stole $25,000 from another individual by fraudulently selling someone that home.
Yeah.
I think based on these circumstances, one moment, I'm just trying to do the math here, 21, 23. I was actually gonna be asking for $15,000 on counts 1, 2, and 4.
Okay. Yeah,
We
they.
couldn't hear what the state said.
The state was asking for a bond increase based on the allegations of the theft through the quitclaim deed, but I'm going to leave the bond as it is, and I do find probable cause. Good luck to you,
Your Honor,
sir.
we asked for an order of no victim
Respectfully,
contact.
what we'd be asking you rather is to consider pretrial release, and this is the reason why.
No.
Mr. Webley.
I'm sorry. Go ahead. Go ahead. Go ahead.
To the state.
No, go ahead, please.
He's been diagnosed with cancer. Right now, he's going through treatment. His doctor's Dr. Mark's out of Plantations. He very much wants to continue his treatment on the outside. He can't financially right now post this monetary bond. That's why we're asking the court to consider pretrial release.
Okay, I'm sorry for his health challenges, and I will be happy to sign an order that he gets all the medical help that he needs in jail until he is able to post bond. But I don't want him financing his medical care by filing quitclaim deeds on people's property and then selling it. Okay, good luck to you,
Your Honor,
sir.
we're just gonna request no victim contact in an abundance of caution.
Oh, okay. All right. Yeah. And should you post bond, you're to have absolutely no contact with either of the victims, either Antoine Johnson or she was. There was another. The alleged victim that
Yeah, I
tried to
think they just
sell it
list the,
to.
the
Well,
original homeowner.
that was Antoine Johnson, I
Yes, I
think.
believe so.
Yeah, okay, no contact with Antoine Johnson. Okay, Julian Ellie.
Judge, I've been advised to bond it.
Oh, okay. And Vincent Capone.
North Broward.
Good evening, ma'am.
Good morning.
Good
Good
morning, ma'am, I
morning.
meant to say.
Yeah, all right. Mr. Capone, you're here this morning charged with delivery of heroin within 1,000 feet of a church. I do find probable cause for the charges. Bond is set in the amount of $7,500.
Your Honor, in regard to Mr. Capone, he advised me that he's been a lifelong resident here in South Florida. He has family here in the area, including his father, who he would be living with. He's basically lived with his father his entire life. He's had the same job with the same roofing company for the last year and a half. He's married. He has 3 children. The youngest is 7 months old. From what he indicates to me, he's not sure how much money his father would be able to come up with to bond him out, but he does feel as though a $2,500 bond would be within range.
Okay,
So
and
based on his prior record, I don't know what it is, but I'd ask the court to consider reducing the bond to an amount that Mr. Capone's family can afford so we can get back to work.
there's priors?
Yes, first, though, while I'm looking that up, I think the nature of the allegations has to be taken into consideration, Your Honor, when considering Mr. Capone's potential financial resources. Out of Palm Beach County in 2011, attempted burglary of an occupied dwelling.
Don't say anything, Vincent.
He was sentenced to a year and a day state prison. Also showing, one moment, Your Honor. Yes, Mr. Capone has a pending theft and unlawful use of false name ID in front of Judge Evans. Actually, he failed to appear in court on that case once already. What else? I'm showing.
Do not say anything right now.
Yes, sir, yes, sir, yes, sir, yes, sir.
Resisting without violence in 2015 out of Hollywood. Possession of marijuana, 2015 out of Hollywood. Resisting an officer without violence, loitering and prowling, 2014 in Hollywood. Resisting without violence, 2014 out of Hollywood. Possession of heroin, resisting an officer without violence, leaving the scene of an accident, 2013 out of Hollywood. Possession of cocaine, 2013, Hollywood.
Okay, all right, I'm gonna leave the bond at $7,500. Good luck to you, sir. John Welter.
Ruth Broward, Your Honor.
Good morning, Mr. Welter. You're here this morning charged with grand theft auto. Bond is set in the amount of $1,000. I do find probable cause. Good luck to you, sir.
Your Honor, Mr. Welter has lived here in Florida all of his life. Unfortunately, he doesn't really have anybody to bond him out. He's going to make the best effort that he could. Would the court consider a $500 bond on Mr. Welter?
Any reason not to do that, Stain?
Just checking to see if he has any history. I don't believe he does. He? Yes. No, I'm showing he is pending. Looks like he's got a pending case out of Dade County, Your Honor. I'm also showing that there's no residence listed, no address. Just asking that the bond be left at 1,000.
Your Honor, his priors include 2014 adjudication of fraud, 2010 burglary of an unoccupied building, also Preston in 2011 adjudication. Your Honor, many priors.
Okay, all right. Good luck to you, sir. I'm gonna leave the bond at $1,000. Chris Carly Planton.
Page 13, did he bond? He bonded?
Planton?
Oh, We're gonna bond it, Judge.
Okay.
Charles Hill Jr.
Charles Hill Jr.
He's here, President Manger.
Thank you. Good morning, Mr. Hill. You're here this morning charged with a violation of your parole. No bond is available. I do find probable cause. Good luck to you, sir. Gibson Sylvain.
Mr. Sylvan is here, present, Judge. We'd be waiving formal reading of the charge.
Your Honor, I'm actually going to be asking if this could be reset for this afternoon. I spoke with the detective. I know the warrant gives, unless you have the copy of the affidavit, I just have a copy of the warrant without the affidavit.
I have just the warrant,
And I know
yes.
the warrant gives some details, but I suspect the affidavit, there'll be more in the affidavit. The detective is gonna be emailing it to me later this
Okay,
morning.
okay, all right, because the state wants the additional information available to make a bond decision request, I'll put it over to this afternoon. I'll reset it to 1:30.
1:30 or 1 o'clock, Judge.
Oh, 1 o'clock, if we can do that.
Fridays, we generally do start at 1.
Perfect, okay. I'll reset it to 1. That's fine. Devontae Coleman.
Mr. Coleman's here, approaching, Judge. He declined the services of public defender. Mr. Coleman?
All right, Mr. Coleman, you're here this morning charged with battery on an officer, selling or offering to sell counterfeited goods, unlawfully taking a law enforcement officer's firearm or attempting to do so, delivery of cannabis, bond is set at $1,000, resisting an officer with violence, corruption, 2 counts of corruption by threat of a public servant. I do find probable cause for the charges. Did the state want to be heard as to bond?
I'm sorry, one moment, Your Honor. If you want to inquire of Mr. Coleman about it, I just need to check one thing, I'm sorry.
Okay, Mr. Coleman, was there something you wanted me to know in connection with bond?
No, sir.
No? Okay.
Sorry, I'm just trying to see the allegations regarding the fire. Yes, Your Honor, I'm very concerned about the allegations that Mr. Coleman tried to reach for the grab the deputy's
Right.
gun. I'm going to be asking on count 1, $5,000 bond. On count 3, I'm going to be asking for a $15,000 bond.
Okay. All right, yeah, go ahead.
I'm sorry, and on count 6, another $5,000 bond, and whatever the court deems appropriate on 5 and 7, I'm fine.
Okay, all right. On count 1, on the battery, I'm setting bond at $5,000. The count 2, it's $100. Count 3, $10,000. Count 4, $1,000. On the resisting the officer, that's going to be $500. And the corruption by threat of the officer will be $1,500 as to each count. And as I say, I do find probable cause. Good luck to you, sir. Joseph Skerich, perhaps?
He's here at main, Judge.
Yes, okay. Sir, you're here charged with grand theft. Bond is set at $1,000. Uttering a false instrument. Bond is set at $1,000. And petty theft. Bond is set at $25. I do find probable cause for the charges. Good luck to you, sir. Bernardo Martins. Anybody have Bernardo Martins?
Judge, I've been advised he bonded.
Thank you. Otis Thomas.
Mr. Thomas?
Okay.
Here present, Judge O'Main.
Okay, Mr. Thomas, you're here this morning charged with possession of PVP. I do find probable cause for the charge. Bond is set at $1,000. Good luck to you, sir. Joshua Wareham.
Mr. Wareham? Mr. Wareham? Wareham? Joshua.
Yeah. Mr. Wareham, you're here this morning charged with possession of heroin, possession of Xanax, and possession of drug paraphernalia. I do find probable cause for the charges. Bond is set in the amount of $1,000 each on counts 1 and 2, and $100 on count 3. Good luck to you, sir. Bryant Smith.
Mr. Smith? Judge, he's here present, Judge O'Main.
Okay. Mr. Smith, you're here this morning charged with premeditated murder and with possession of a weapon or ammunition by a convicted felon. I do find probable cause for the charges. There's no bond available as to count 1.
Your Honor, I apologize. On count 1, the state is going to be seeking a no bond hold, arguing under Isaza v. State that for first appearance purposes only, based on the probable cause affidavit, that proof evident or presumption great exists, noting specifically Mr. Smith was found in a vehicle matching the description of the vehicle that left the scene of the shooting. He was identified by an independent witness. 2 guns matching the description that were given of the guns used in this matter were found on the floorboard of the right passenger seat where Mr. Smith was seating. Additionally, bullets found in one of the guns matched the casings that were left at the scene where the shooting occurred, Your Honor.
Yes. Okay.
And again, Judge, we would object to the state is asking for Mr. Smith to be held without bond, which is the most severe pretrial sanction. They have introduced no evidence. They've called no witnesses. All they have presented to this court is a probable cause affidavit, and that is insufficient to reach that very high standard of proof evident presumption great. We would ask you to set a bond for Mr. Smith.
Okay, thank you. Based on Isaza, the proof evident and presumption great can be found from the probable cause affidavit, and I'm going to find that and leave the no bond. On the possession of a weapon or ammunition by a convicted felon, that'll be a bond in the amount of $2,500.
Your Honor, at this time, we're going to be invoking Mr. Smith's right to remain silent. We
Absolutely.
would ask that no agents of law enforcement or the state attorney's office attempt to contact Mr. Smith. That document, we will be filing a document to that effect within the next 24 hours. And Mr. Smith, we're advising you not to discuss your case with anyone. Do you understand that, sir? Yes.
Okay, Mr. Smith, you understand that? Don't talk to anybody and don't let anybody talk to you. You understand that?
I spoke to him, Judge.
Thank you. Okay, good luck to you. Luis Granados.
Mr. Granados here present, Judge O'Main.
Yeah, Mr. Granados, you're here this morning charged with possession of cannabis over 20 grams. Bond is set in the amount of $1,000. I do find probable cause for the charges. There's a traffic infraction, of course, requires no bond. Okay, good luck to you, sir.
Judge, the only thing I'd be requesting, considering this is a nonviolent offense, possession of cannabis, we'd be asking you to consider an ROR.
State you want to be heard?
No, Your Honor. Judge,
No objection to the ROR?
He has a pending case, doesn't he?
does he? Then, Your Honor, if he has a pending case, the state would object to an
Yeah.
ROR.
He seems to have a pending case, according to pretrial. Okay, good luck to you, sir. Preston Honeycutt?
Judge, before we move on from Mr. Granados, I had read this probable cause affidavit before, and I'm reading it through again, but I don't see a weight on here that would make it over 20. Oh, synthetic over 3.
Yeah.
Okay, I got it.
Preston Honeycutt?
Mr. Honeycutt is here present, Judge O'Main.
Okay, Mr. Honeycutt, you're here this morning charged with unarmed burglary of an unoccupied conveyance and with petty theft. I do find probable cause for the charges. Did the state or public defender wish to be heard as the bond?
Your Honor, Mr. Honeycutt's criminal history includes resisting without violence, 2013, theft, 2014, battery on a law enforcement officer, 2013 with a violation of probation, and 2012 possession of oxycodone with the violation of probation. State is requesting a $3,500 bond on count one.
Anything from the public defender?
Judge, and speaking of Mr. Honeycutt, he's self-employed. He does moving jobs. His amount of earnings fluctuate. Judge, we'd be asking you at this time to consider reducing the bond from $3,500 to $2,500. That $1,000 might make a difference, and he might be able to contact his mother to help post his bond.
Okay, all right, I'll reduce it, I'll set it at $2,500. Good luck to you, sir.
Thanks, Judge.
Edward McKinney.
Mr. McKinney's here present, Judge, at Maine.
I see. Mr. McKinney, you're here this morning charged with possession of cocaine. Bond is set in the amount of $1,000. There's also possession of paraphernalia and driving with a suspended license. No bond necessary as to those charges.
Sure, he does have a prior record, just to let the court know, however, he has been verified, if the court wants to place him on supervision.
Okay. All right, there's been a recommendation made that you be admitted to pretrial release. I'm going to adopt that recommendation and put you on pretrial release. And there'll be the pretrial release is standard conditions, and of course the condition of no intoxicants and random drug testing at your expense. And you will need to present yourself at the Office of Pretrial Release.
Submit to a drug evaluation
And-
and random urinalysis
Right.
at his own expense.
Submit to a drug evaluation, the follow-up treatment, and of course, as I said, the random testing at your expense. And you'll need to report to pretrial services immediately upon your release from jail today. The other charges, I'm just gonna send you a copy of your driver's license, so you'll see what needs work. Okay, good luck to you, sir.
Thank you.
Raheem Ralph.
Mr. Ralph, come on. You posted bond? I'll inquire. Mr. Ralph is here present, Judge, at Maine.
Yeah.
One, he declined the services of public defender. Number two, he wishes to see if his bond has been posted, Judge.
Yes, his bond has been posted. Okay, so on the charge of grand theft of a firearm, the $1,000 bond has been posted. I did find probable cause. Good luck. Justin Williams.
Mr. Williams is here present at Maine.
Okay, Mr. Williams, you're charged with tampering with evidence. Bond is set at $1,000. And possession of marijuana under 20 grams, no additional bond being necessary there.
Judge, I would make a probable cause argument as to the tampering of physical evidence. It appears as though taking the evidence in the light most favorable to the state, it appears that the marijuana was already in Mr. Williams' mouth when the officer approached. There was no indication it was evidence at that time. It's not as though the officer saw the marijuana and said, leave that alone or give that to me, and then Mr. Williams put it in his mouth. It was already in his mouth, so there's no indication as to when he might have done that, if he did it, and that's not tampering.
Your Honor, considering that it was still in the baggie, I mean,
Well,
for what reason would someone have to start putting a baggie of marijuana in their mouth?
Well, and I think it's a reasonable conclusion that when he was pulled over for the traffic stop, that it might have occurred there. So I'm finding probable cause. Good luck to you, sir. Wilson Geffrard.
Come on up, sir.
Okay, Mr. Geffrard, you're here this morning charged with possession of cannabis over 20 grams or synthetic over 3. Bond is set at $1,000. Possession with intent to sell, manufacture, or deliver cannabis. Bond is set at $1,000. and a traffic infraction that requires no bond. I do find probable cause for the charges. Good luck to you, sir. Timothy Williams.
I believe he's a medical loan, Judge.
Oh, is that right?
Judge been advised medical loan.
Okay. Okay. Goodness. Not sure what that sound was, but. Darren Darrington.
North Broward, Your Honor.
Mr. Darrington, you're here this morning charged with possession of Xanax. Bond is set at $1,000 and a violation of your felony probation or community control, as to which no bond is available. I do find probable cause. Good luck to you, sir. Henniston Francis.
We waive formal reading.
Okay, Mr. Francis, you're here this morning on some sexual assault charges. I know that you've waived formal reading, but there's been changes of charge from Judge Cohn to now. So let's see, there's 1, 2, 3, 4, 5, 6, 7 counts of sexual assault by a custodian, someone in a custodial
Judge, we are
capacity.
waiving formal reading of the charges.
Okay, it's just that some of the charges were changed from when Judge Cohn found probable cause and set bonds.
I understand, but if we
Okay.
could keep it at a minimum.
Okay. And there's also 3 felony capiases.
Those are ad charges, Your Honor.
Those are ad charges here, okay, that bond needs to be set at. But, okay, so, count 1, did the state want to go with the,
On the change of charge counts, Your Honor, and I provided both defense counsel and the court with a copy of Judge Cohen's original findings, the information that the state filed, and the probable cause affidavit that Judge Cohen reviewed at his initial first appearance. On counts, on the, and I guess I'm just going by what's on my booking sheet, because I don't know how they're numbered on the findings. Charge numbers 1, 2, 3, 4, and 10 through 13.
well, 10 through 12 are the same charge. They're all the same charge.
Yeah,
13 is,
it's basically the custodial charges.
yeah,
And the one count with the one count where it's also
right.
victim under 12. We're going to be requesting that the court adopt Judge Cohen's initial previous findings. We're going to be seeking a finding of proof evident presumption grade on these counts, and then no bond holds.
Okay, so 1 through 4 and 10 through 12 were set at $50,000 each by Judge Cohn.
Yes.
Okay, and I'm going to keep that amount.
Well, Your Honor, they are punishable by life offenses now.
Right.
So we.
Oh, so you're asking
We're
not to
seeking no-
keep it at
No, we're
50,000?
seeking no bond on those now, because
Okay.
when he went before Judge Cohen, Judge Cohen had to set a bond. He was constitutionally entitled to a bond. Now
Right.
that we've changed the charge to punishable by life offenses.
Oh, okay, I thought you said you wanted to stick with what.
No.
Okay,
no.
that's fine. I understand your position. Okay, and as to 13 as well,
Stays taking the same position.
Okay.
That's a punishable life.
and what about 25, 26, and 27?
On those, we would ask the court to set the $50,000 bonds that.
Oh,
Judge
those are the
Cohen-
ones that you want to keep Judge Cohn's, okay.
Yeah, I mean, those are ad charges, but I'm just basing the recommendation based on which Judge Cohen deemed appropriate at the first appearance for
Okay.
similar counts.
Okay. All right.
If I'm reading this correctly, and maybe the state can help me verify this, on counts 5, 6, 7, 8, and 9, and 14. He is, and 21, and 22, and 24, and 23. He is currently being held no bond. Is that correct?
I know on some of them he is being held no bond.
That being the case, Your Honor, since Mr. Francis is being held no bond on other charges, the defense would reserve any argument regarding proof, evidence, presumption great at this time.
Okay. All right. Then, based on all the allegations and the prior findings of Judge Cohn and the content of the information, for today, I'm finding proof evident and presumption great and no bond as to the remaining counts. So 1, 2, 3, 4, 10, 11, 12, 13 are no bond, and 25, 26, and 27 are added on the felony capias, and we'll leave those as no bond as well for it all to be handled together.
Your Honor, the only additional thing I'm going to ask for, since some of these counts do have bonds attached, is Judge Cohen, as you can see in the findings, Judge Cohen also originally ordered no contact with the minor victims or their mother,
Right.
and not to come within 1 mile of their homework or school. We just asked the court to adopt
I'm going to adopt those, and it doesn't appear to me that Judge Cohn ordered the appointment of a guardian ad litem.
I obviously have no objection if the court.
Okay. So in addition to no contact with the minor victims or their mother, and the condition not to come within 1 mile of their homework or school, I'm also going to order that the guardian ad litem be appointed for the interests of the minor children. Okay, good luck to you, sir. I do find probable cause, I'm sorry. Appoint the guardian ad litem for the minor children.
I believe we have our Creole interpreter.
Okay, all right. And is this our Creole interpreter? Awesome, okay, I think they were all in the main jail. Do you swear that you'll accurately and completely translate everything I say to the Creole-speaking defendants and everything they say to me?
Yes, Your Honor, I do.
Okay. Just put your name on the record for us.
Pierre George.
Okay, thank you. Let's recall Jeff Delva.
Mr. Delva's here present, Judge?
Okay, Mr. Delva, you're here this morning charged with robbery, with grand theft, and with resisting an officer without violence.
So donc, Monsieur Delva, donc raison que yo kembe ou là, c'est parce que yo gen gros accusation yo lage sou do, accusation de vol, gros vol, et ou te résisté yon la police pendant que yo tap essayé arrêter ou mais ou pas fait ça avec violence.
I do find probable cause for the charges.
Li wè que gen bon jan la cause pour accusation sa yo.
Okay, and does the state or public defender want to be heard on the issue of bond on count 1?
Your Honor, with regards to Mr. Delva, the state is requesting on count 1 a $7,500 bond.
So pour accusation numéro 1, y a pas demandé pour yo lage ou pour accusation numéro 1 $7,500.
Based on the level of violence alleged in the affidavit.
Surtout avec violence qui était faite sur affidavit là.
Okay.
And just noted the strength of the evidence against Mr. Delva and his co-defendants involved, including the property being found, stolen property.
So donc tout ça avec Monsieur Delva et co-défendant yo, surtout que yo te recevoir ça que yo te volé.
Okay, and did the public defender want to talk to Mr. Delva through the interpreter?
Judge, I've spoken with Mr. Delva. He speaks English, but his native tongue is Creole. He wanted to go with the Creole interpreter, so and all 4 of these gentlemen did, just to fully understand every single word. But in speaking with Mr. Delva, he's been residing in our community for the past 14 years. I'll let the interpreter go.
So donc m'te parlé ensemble avec Monsieur Delva, donc bien que li parle anglais, donc il a préféré pour bien comprendre bail en créole. Donc et il t'a aimé bien comprendre tout ça que y a dit là dans processus légal ça yo.
Like I said, he's been residing here in our community 14 years. He's 21 years old. He is currently employed, works at McDonald's. He makes approximately $300 a week. Besides that, Judge, he plans on attending Broward College. He's gonna try to enroll for this fall semester.
So, donc, j'aime te dire ça déjà. Donc, M. Delva dans la communauté a pendant 14 ans. Donc, quand il a 21 ans, il travaille actuellement dans McDonald's, côté il fait $300 par semaine. Et il pense pour inscrire dans l'école à Broward College. Là, et il pense pour inscrire dans l'école ça dans été qu'à venir.
He lives in Fort Lauderdale. He lives in Fort Lauderdale with his father. He's going to be contacting his father to help post his bond. From what Mr. Delva advised me, his father works at the Embassy Suites. Judge, like I said, he's a U.S. citizen. This is his first arrest, first contact with the criminal justice system. Respectfully, we'd be asking you to consider a bond on count one of $3,500 on Mr. Delva's behalf.
Okay, on count one, I'm gonna set bond in the amount of $5,000. On the grand theft count, bond is $1,000, and on the resisting an officer, bond is set in the amount of $100. In the event, sir, that you post bond, you're to have absolutely no contact, just to have no contact with Darrell Coleman or Jackie Wilson, the alleged victims. Good luck to you, sir.
So, donc, quant à pour accusation en vol là, donc, m'a mette en $5,000 bonne. Quant à pour grand vol, c'est $1,000 bonne et résister à arrêter, yo, c'est $100 bonne. Donc, quel que soit ça que vous décidez de faire, si vous pas poster bonne nom, vous pas droit gagner aucun contact avec Darrell Coleman et Jackie Wilson, donc deux moun ça qui impliqué dans affaire ça.
Okay, Mark Desir.
Marc Désir.
Judge, he has some members of the community here on his behalf.
Okay, very good. Is there somebody that wants to come to the podium and tell me something about Mr. Desir? Come on up, ma'am. Come on up. Okay, Mr. Desir, you're here this morning charged with robbery, grand theft, and resisting an officer.
Monsieur Désir, donc raison que yo amène là aujourd'hui, c'est parce que yo gen accusation de grand vol et les ou te résisté, yo arrêté avec un officier.
I do find probable cause for the charges.
Juge la joindre que gen bon jan raison pour accusation ça yo.
Ma'am, is there something that you wanted me to know, either about bond or?
She's asking whether to speak in Creole or English.
Well, if you need the Creole interpreter or want the Creole interpreter, speak in Creole. If you're comfortable in English, speak in English.
Okay.
First, tell us your name.
All right, my name is Fazlane, and I am Mark's cousin. And Mark, c'est un bon petit mounier. Et puis, même avec Mark, nous étions dans la même école ensemble. Et puis, Mark, c'est cousin. Et puis, papa Mark te mouru, like, 3 ans passés. Après ça, pour m'attendre Mark dans le ça tout, it makes me hurt for me to hear that.
So I just want to let you know that I am Mark's cousin. We grew up together. We grew up in the same school. And so Mark is truly a good person. Not too long ago, about 3 years ago, his father passed away, which was pretty shocking. And for me to hear that Mark has gotten into this type of trouble was very hurtful to me.
Okay, thank you.
Merci.
And, Your Honor, just to save time, I'll just have the same argument for all the co-defendants requesting a $7,500 bond.
Okay, and
Judge,
yes.
as far as the defense goes, like I said, this is his first arrest ever. He's currently going to Broward College. He's studying to be a paramedic. He's been residing in our community for the past 6 years. He's a delivery driver for a restaurant in Hollywood. He lives in Fort Lauderdale with his mother. We'd be asking you on his same thing, $3,500 bond on count one.
Okay, all right. As to Mr. Desir, I'm going to set bond on count one in the amount of $3,500, grand theft $1,000, the resisting an officer $100. You're to have absolutely no contact with Darrell Coleman and Jackie Wilson, and You want to keep up your attendance at Broward College. Good luck to you, sir.
So, donc, pour M. Coleman, donc, juge là a demandé $3,500 pour vol là, $1,000 pour grand vol là et $100 pour résister, que vous résisté, il a arrêté. Donc, si vous décidez pour poster bon ça, vous pas droit faire contact ensemble avec Daryl Coleman et Jackie Wilson.
Okay, good luck. Phil's Magre,
Bonne chance,
Eston
merci.
Phil.
Phyllis Margaret, Estefil.
No? Can he see that they're here?
Yes, Judge, he has family members here. They
Don't want to.
I guess one person
somebody's
wants
gonna
to
speak.
address the court.
Okay, fine.
There are other family members here as well.
Right, I was just wondering if he could see who's here without them coming to the
Yes, we
podium.
can see them
Okay.
at the podium, but not really in the.
Oh, that's what I was asking, okay. Mr. Estenfield, you're here this morning charged with robbery, with grand theft, and resisting an officer without violence. I do find probable cause for the charges. Ma'am, did you want to say something?
Yes,
Tell me your name
Tracy Michelle,
and your relationship,
he's my husband.
okay?
I want to say that he's a good person. He's not really a troublemaker. Sometimes he does get caught up, but he's really a good person. He's a person that wants to make it in life. And whatever the bond is, I just, hope it's not too much because we just had a baby together and I'm not really working right now. I'm going back after 3 months.
Are you able to post a bond on his behalf?
At the moment, yeah, his family members,
Okay.
depending on the amount. But, yeah.
Okay. All right, anything else from the public defender? The state, you have the same position?
Nothing additional from the state.
Anything else from the public defender?
Judge, the only person, he's gonna be contacting his mom to help post his bond. She has 2 jobs, works at KFC and at a hotel. He graduated from Maverick High School. He's planning on enrolling in Broward College. He's currently looking for work. He lost his job at a restaurant. He was a dishwasher. We'd be asking you to consider a $3,500 bond on count 1.
Okay, and on count 1, I'll go ahead and set it at $3,500, $1,000 on count 2, and $100 on count 3. You have a lot of family here who are prepared to post a bond for you, Mr. Estenfield, so don't let them down. Good luck to you.
So, donc, M. Estenfield, donc, juge a décidé pour 3 accusations qui ont lagué sous ou grand vol là, et là où tu résisté, yo arrêté pour mettre $3,000 pour grand vol là, $1,000 pour vol là et $100 pour résister arrêté. Donc, M. Estenfield, ou bien en pile famille qui vient là pour présenter devant le juge là, pour supporter yo d'accord pour yo poster bon pour ou s'il vous plaît, donc pas décourager yo et pas faire yo sentir mal d'être que yo fait ça.
And also, no contact with the alleged victims, Daryl Coleman or Jackie Wilson.
Et donc, ou pas doit faire contact ensemble avec Daryl Coleman et Jackie Wilson, moun qui impliqué dans ça fait ça.
Good luck.
Bonne chance.
Wak Geffrard?
Mr. Jaffard is here.
We have family members here on his behalf as well, Your Honor.
Yes, thank you. Good morning, sir. You're here this morning charged with robbery, grand theft, resisting an officer without violence. I do find probable cause for the charges. Yes, ma'am, there's something you want me to know?
Donc, monsieur, donc, yo accusé pour grand vol et ou te résisté à yo arrêté ou. Juge la joindre que yo gen bon raison pour accusation ça yo. Gen moun là qui t'a même parler pour ou.
Okay, I need to know your name if you want to speak, and I need you to speak up and speak into the microphone.
My name is Julene Brave, and this is my son.
Are you able to post the bond for him?
Est-ce que ou en position pour poster un bon pour yo la le tempérament? Yes.
Okay.
So since this is my child, he's never been disrespectful, always a good kid. I haven't been able to hear from him since yesterday. I don't know whether he's eating. I haven't been able to eat myself.
All right. Anything else from the public defender?
Judge, he's currently going to school. He goes to Whittam Rogers. He's in 12th grade. Besides that, he is working, works at the quarterdeck. Been working at the quarterdeck now for about 2 years, making $805. His mom, from what he advised, is a stay-at-home mom. His father is the one who's going to be he's going to be relying on to post his bond. He works at Walmart as a cashier. We'd be asking you to same thing, a $3,500 bond on Mr. Trufford's behalf.
Okay. State have any different position on this, co-defendant?
No, Judge.
Okay, all right. On the robbery, I'm setting bond in the amount of $3,500. The grand theft has bond of $1,000. The resisting an officer without violence, bond of $100. As I said, I do find probable cause you to have no contact whatsoever with the alleged victims, Darrell Coleman or Jackie Wilson. Okay, good luck to you, sir, and good luck to all of you folks. Thank you all for coming
Donc,
to be heard.
donc, Monsieur Geoffroy, donc, juge là, ouais, que y a bon genre raison pour accusation ça yo, donc, il demande pour yo poster bon pour yo la yo à $3,500 pour vol là, $1,000 pour grand vol là et $100 pour résister, yo te arrêté yo. Donc, ou pas gen droit gen contact ensemble avec Darrell Coleman, Jackie Wilson. D'ailleurs, me remercier moun qui vient là pour supporter et parler pour vous et tout l'autre moun yo qui te venu là pour présenter devant un juge là pour parler pour moun qui en prison yo.
I'm also going to ask the interpreter to remain for a few minutes in case the public defender would like to talk to any members of the family and might need your services as well. Okay?
So, donc, on a pas demandé pour interprète l'arrêté là, en cas que juge avocat pour défense là, t'as même parlé avec aucune famille yo, pour poser nous aucune question pour aider cas yo.
Thank you.
Judge,
Yes.
just one last request, if Your Honor would indulge me. I know Your Honor has already made a decision regarding Jeff Delva. That was the first gentleman. You set a bond at $5,000. The only thing I would respectfully ask you to reconsider is setting it at $3,500. It would be the similar bond as his co-defendants. Once again, he was never arrested before.
Yeah, I'll reduce that to $3,500.
Thank you, Judge. Appreciate that.
Sure.
I don't.
That now they have Tammy Lee Parent. I thought maybe she had bonded, so when I did the
Oh, yeah,
perfection.
no, I
and
mean, if
really-
you just want to advise her real quick, she's being our
Right.
count one, obviously, yes.
Right.
Sure.
Yeah. Okay, Ms. Parent?
Yes, ma'am.
Okay, the state did not provide any additional evidence, so you're being released on your own recognizance on the remaining counts that no probable cause was shown for. Okay, good luck to you.
Wait, one question. So I don't have to pay any bond at all?
She has account 3, which is a capious, and I believe there was a $500 bond on that.
Okay, this is only as to counts 1 and 2, okay? If there was a capious that had a bond, that the judge yesterday found probable cause on that, and that bond, I think, was $500 from the paperwork. You have to post that bond, okay?
Is there
You
any
just,
way- Is there, sorry. I didn't
No,
mean to-
no, there isn't.
Okay.
Okay, because I don't have any of that paperwork because that was all done yesterday, okay? So you can post that bond, or that will be heard in the division, but I don't have that date for the division date because that wasn't in front of me today. Okay, good luck to you, ma'am.
Okay. Thank you.
Sure.